In most states, it is generally not illegal to check someone's credit without a written credit application. However, there are exceptions and specific requirements that vary from state to state. Regarding Massachusetts specifically, the law does not require a written credit application before a credit check. However, there are certain disclosure requirements that must be met. The Fair Credit Reporting Act, or FCRA, is a federal law that regulates the use of consumer credit reports. Under the FCRA, one may obtain a consumer credit report for business purposes without a written credit application in the following circumstances. Firstly, one has a legitimate business need for the information. Secondly, one has provided a clear and conspicuous disclosure to the consumer that a credit report will be obtained. And thirdly, one has a permissible purpose under the FCRA, such as evaluating a credit application, even if the consumer has not applied for credit with you. There are some exceptions to the general rule that one does not need a written credit application to check someone's credit. For example, in Massachusetts, one may need a written credit application for the following: firstly, obtaining a consumer credit report for employment purposes, and secondly, obtaining a consumer credit report for tenant screening. Although it is not always required, it is good practice to obtain a written credit application before checking someone's credit. This can help protect one from legal challenges and demonstrate one's compliance with applicable laws. In conclusion, in Massachusetts, it is generally not illegal to check someone's credit without a written credit application, as long as you meet certain disclosure requirements and have a legitimate business need. However, obtaining a written credit application is a prudent practice to minimize potential legal risks.